I think it is also very, very important as we look at the interrelationship of the rights of the child to say that uh, in a context where the child's connections are not honored, the CHIP is concerned about identity rights, and there are really different elements of identity rights that are key here. One is when we sell a child, we're selling the child's identity. We're selling the child's parentage. We're selling the child's parental responsibility. We're also potentially, in an international context, selling the child's nationality, the child's family relationships. All these things are on the auction block. And so essentially, as to children's identity, a commercialized context is not a context where we can protect the identity rights of children. Of course, back to the US, there are no protections even for informational identity in the surrogacy systems in the US. So in California, the original birth certificate shows only the names of the intending parents. There are no obligations to store or make available the genetic or the gestational background of each child. Because again, that's not what intending parents want. Intending parents want that to be at their discretion, not a matter of the rights of the child. So commercialized systems are devastating to children's identity rights. There are a lot of questions about the link of genetics to surrogacy, okay? I think that it is certainly true that intending parents who are genetically related might, in a best interest of the child situation, have a very legitimate claim to be a parent or of this child. Genetics is complicated because, and I certainly don't have time to go over all of the family law issues in all different countries, but suffice it to say that traditionally genetics is not necessarily the keynote of parentage around the country. Traditionally, the woman who gives birth is the mother, and if she's married, the husband is the father unless something else is shown. So then we get the objection that to the degree that one or both intending parents are the genetic parent, and often it's one, sometimes it's two, should they automatically be the parent or parents? I think what we would say about it is that as to the sale aspect, even if you have a legitimate claim to be a parent, nonetheless, you cannot buy exclusivity. And that essentially is what intending parents want. They not only want to be the parents, they want nobody else to have any claim on the child. And that's the part which we say cannot be sold. It may in the end be in the best interest of the child that they are the only parents, as we surmise that after birth, when we can do a proper best interest of the child review in a court. Commercial surrogacy cannot, by paying money, bypass the complexities of a best interest of the child review of a child who may have genetic heritage in one place and also with a donor perhaps, and also a mom who has carried them and given birth who may or may not be interested in carrying them. That we're not really trying to make a statement about surrogacy and parentage ultimately. We're just saying it can't be bought and sold, that it's subject to best interests of the child review.